Topic that we will discuss today, that is contract law. Though we have discussed every aspect, every terminologies and all the principles of contract by the time, but in this video we will revise the things. We will see what are the major topics, what are the major terminologies, principles that we have discussed by the time. So let's begin with the topics of contract. So the first topic under the topics of contract that we have discussed, that is of course meaning and concept of contract. What contract is? I believe you must remember that what contract is. This is enforceable agreement. Simple. So contract is an enforceable agreement. So second chapter that we have discussed, what was that? That is formation of contract. How a contract is formed, that we have discussed all the aspects of a formation of a contract. The third aspect of the contract that we have discussed, that is discharge of contract. What are the possible means through which a contract can be discharged? Okay. The next chapter that we have discussed under the contract law, that is breach of contract. So what is the meaning of breach of contract? What is remedy if someone breaches? So all these aspects that we have discussed under the heading breach of contract. Next one we have discussed, that is contingent contract. So what is meaning of contingent contract? What are the principles of contingent contract? So we have discussed all these aspects under the heading of contingent contract. So if you remember, contingent contract is something like that depending upon the future event. Okay. So if something will happen, then this contract will be valid. If the event that won't take place, then this contract spontaneously will invalid. Okay. And the last topic that we have discussed under the contract law, that is waiver. Of course, waiver is a sort of contingent contract, but it is not contingent contract in the sense that waiver is an illegal act. However, the contingent contract is a legal act. So this is the only difference. Otherwise, couple of more differences are there that we have discussed while discussing the contingent contract. So we don't supposed to be explaining all those things because this is revision class. However, if you feel something like you have confusion, then you can go back and just see that video in order to again revise the things. Okay. Now again come back to the first topic, that is formation of contract. What are the principles that we have discussed under the formation of contract? The first one of course was agreement. Okay. So what is agreement? Okay. Then capacity, that is the involving in a contract, capacity must be there in the sense that either he is minor or major and who insane, okay, or something like some criminal and some traitor. So all these aspects are covered under the capacity. So who can contract? Who has the right to contract? So we have discussed all these things while discussing the concept of capacity. The next principle is free consent. Of course, it is not only consent, rather free consent. Means the person who involved in this contract signing the agreement is not doing so under any threat, pressure, deception or any sort of such kind of thing. Rather it is completely, entirely his or her free will. Only then it will be possible to make a valid contract. Next one is consideration. Of course, what is consideration? Well, it is something like reciprocal relationship. Mutual benefit means if I am giving something you, then you returning back to me something. For example, I am selling my car, so you wanted to buy that. So you are giving me money and I am giving you car. So in my case, money is consideration. In your case, car is consideration. Okay. The last one is lawful object. What does it mean? That we have discussed, although while discussing lawful object in detail. So lawful object something that under the law, permitted under the law to trade. Means if something like drugs, some arms, weapons, those are the object that we cannot trade. That is, trading of such objects is illegal. So if we are making contract regarding such an illegal object, then that is not a valid contract. Okay. So these are the principles of formation of contract, starting with the agreement, capacity, free consent, consideration and lawful object. So there are 5 principles. Okay. Now let's check out agreement again. So what is agreement and what are the major features of an agreement? That is offer. The first feature is offer. The second one is acceptance, means if I am offering that I am selling my car, or basically proposal. So I am selling my car. So if you are interested in buying that, so you are accepting that. So first offer that I am giving you, or proposal, either word you can use, and then you are accepting, that is acceptance, and then measure, that you must be measure. If you are a minor, means below the age of 18, then you cannot involve in a valid contract. So you have to be measure and sane mind. Okay, the last one, that is sound mind. So if you are even measure but insane mind, then you cannot. So likewise, there are 4 features of agreement, that is offer, acceptance, measure and sound mind. Okay. Now again come to discharge of contracts. So what are the major modes of discharging the contract? So we have 6 major modes of discharge of contract. That is by performance. Of course, this is the most ideal way of discharging the contract. For example, you and me have made the contract that I will do certain task for you. So for example, I said that I will paint your house. So I did that and you paid me 100 rupees, that as discussed in the contract. So you performed your part, I performed my part. So contract is discharged. The moment I painted your house and you paid me money, the contract is discharged by performance. So this is the most ideal way of discharging the contract. Secondly, we have by agreement of contract. So by agreement of contract, though we have made the agreement to form a contract, but again to discharge a contract because of any reason, we are making an agreement. We can, with mutual understanding, we can discharge without performing. Okay, or we can change terms and conditions of the agreement or contract through an agreement, basically through a new agreement. So let's check out what are those agreement through which we can discharge the contract. The first one is novation. Novation, that already we have discussed in detail, that is if something new introducing in the existing contract, or altogether discharging the existing contract and replacing with the new one. So the first one in this case is discharged, that is with mutual consent. The second one is rescission. So what is meaning of rescission? Rescission means simply revocation, cancellation of order, agreement. So, with the mutual agreement, both the parties can terminate the contract, that is through rescission. Next one is alteration. Of course, with the mutual agreement, both the parties can alter the part of the contract. Okay? Then remission. What is meaning of remission is either you are waiving off the whole liability of your promisee or part of that. Means if A owes 1000 rupees, then what B said that okay, I waive off your all money, you don't need to pay anything. Okay, so that is remission. But we can also say that I waive off 500, you just give me only 500. Or we can also say that you give me this property that is worth of 500, 600 or 200, and I will waive off your all the liabilities. That is under the agreement. So that is remission. Next one is waiver. What is meaning of waiver? That both the parties with the mutual agreement, with mutual consent, waive off their liabilities. I won't do this, you won't do that. Fine. The contract will be discharged. Last one is merger. What does it mean? That the existing contract can be merged into some other contract. Maybe it is new or maybe it is already existing but separately. So if two contracts going on parallelly, so through merger, both the parties with an agreement can merge both the contracts, and now from onwards it is one contract with fresh terms and conditions. Okay, so based on the agreement, the discharge of contract can be discharged by 6 means. That is, first one novation, second one rescission, third one alteration, fourth one remission, fifth one waiver, and sixth one merger. Next one is by impossibility of performance. Well, what does it mean? That if something become impossible because of the things that happened that is beyond the parties' contract. So say like a person who contracted dies or met with an accident, so not able to perform his part, and that is beyond his control. So in this condition, the contract, the obligation created in the contract become impossible. So it is impossibility of performance. Next one, lapse of time. Well, of course, if certain contract is contracted that has to be performed in a given period of time, in that case, if time lapsed, then the contract will automatically discharged. Okay, so that is discharge of contract. Next one is by operation of law. What does it mean? That operation of law, that is, if certain rules and regulation allowing certain things. For the example, let's understand it with an example, that will be easier to understand it, though I have explained it in detail, but again for the revision purpose I am just giving brief. So in Bihar, take the example, a few years back the trading of alcohol was allowed, but a new law introduced, and according to that, drinking of alcohol in Bihar became illegal. So by operation of law, here if a person contracted for 5 years to trade alcohol in Bihar, but in the middle of that, means after 2 years, law, that is new law introduced and it became illegal. So of course next 3 years that won't be possible to trade that because it became illegal. So that is operation of law. The contract is discharged at this point in time only. Okay. The next one is breach of contract. We have discussed this topic in detail, and there are many aspects that I have discussed while discussing the breach of contract. So, breach of contract means that is whatever the liabilities that is arised because of the contract, and if any of the parties not intended to perform his part without any reasonable reason, then that is breach of contract, and in such a case he or she will be liable to pay the damages, the loss that other party suffered. Okay. So, this is the breach of contract. So, under the heading of discharge of contract, we have 6 types of modes of discharge of contract, that is by performance, by agreement, by impossibility of performance, by lapse of time, by operation of law, and by breach of contract. So, these are the things that we have discussed under the heading of contract law, and this is all for the contract law. So, if you didn't understand anything, or you felt any point in time that this point is or term is difficult to understand, I request you to go back and watch that particular video made on the topic that you have the confusion on. Okay. So, this is all for this video. See you in next video with new topic.